Hey Cheyenne East, Jeff Pope back again. This time we're going to talk about the 2020-2021 topic on criminal justice reform. This video is going to cover the basics of the resolution, some key words that you're going to need to know about the resolution, and some key facts that you're going to need to know about the resolution. We'll talk more in depth about the areas of reform, policing, sentencing, and forensic science in some follow-up videos. But for now, let's talk at a high level. By now, you've likely seen the resolution. It is resolved the United States federal government should enact substantial criminal justice reform in the United States in one or more of the following: forensic science, policing, sentencing. Now, like every resolution, it is the United States federal government as the actor. That, as you hopefully know, could be the executive branch, Congress, or the federal court system. Now, we're going to talk in just a moment about why this particular topic very likely calls for one of those branches of the federal government to act. Criminal justice reform is obviously an important part of this topic because we have to figure out all of the things that goes into our criminal justice system. And then, of course, understanding forensic science, policing, and sentencing will be critical. But let's start with the key words, three of which are the main focus of the resolution, and then we have the areas of reform. The first word I want to talk briefly about is the use of the word substantial. We have this word in almost every single resolution that high school or college debaters have ever engaged. Now, substantial in some form or fashion means big, large, maybe it's a percentage, depending upon how you want to define it. But the key takeaway is that the criminal justice reform that this topic calls for has to be big. It has to be something that probably fundamentally changes policing, sentencing, or forensic science. Like any other resolution, we want a large-scale change because that ensures that there are people writing about it. There's research available for both sides on the affirmative and on the negative. So when you think about this resolution, when you think about topicality arguments, keep an eye out for how large a potential change the affirmative intends to make. Enact is the next word, and I alluded to this at the beginning. Enact very likely means legislation. Courts don't enact things, they decree things, they interpret laws. The executive agency enforces, they create regulatory policy, but they don't enact. Enact very likely refers to legislation. Legislation is enacted by Congress, and then it is signed by the president, which means that the criminal justice reform very likely has to involve Congress as the actor. You may see affirmative teams try to use the court system. You may see affirmative teams try to use the executive branch of government, maybe an executive action or an agency action. But this very likely is not topical, so have your topicality file at the ready. Third key term, criminal justice reform. I mention that here because it is a term of art. We have a tendency sometimes to simply define individual words as they appear. So we could define criminal, we could define justice, and we could define reform. But a term of art is something where a phrase in a specific context has a specific meaning. Criminal justice reform certainly is a phrase that is used in a specific context and as a result carries a pretty specific meaning. You may get some people who disagree exactly about what that is, but it is certainly not a piecemeal set of definitions for what criminal justice reform should mean. So as you research and as you think about the topic, keep an eye out for where that term of art is used and understood. Finally, we obviously have to understand the areas of reform. And like I said, we're going to talk about those in separate videos. But before I go any further in this topic analysis, it is crucial that we understand the criminal justice system because criminal justice reform affects this system. And if you understand this system, what goes on in this system, then you're actually going to understand a lot of the topicality arguments, a lot of the disadvantage arguments, and frankly, some of the case issues like the solvency of particular affirmatives. So on the screen now, you will hopefully see a breakdown, assuming I've done PowerPoint correctly, a breakdown of the criminal justice system. Now, we're going to talk a moment about how we have multiple systems at the federal and state level, but largely this is true no matter which system you're talking about. So let's begin in the top left with police, or law enforcement as they're sometimes called. Their role in the criminal justice system is pretty well understood by most folks. They are the investigators. They are the folks who get tipped off when a crime may have been committed, or when they see a crime being committed, they try to interdict the person committing that crime. They are called to the scene of crimes. When you dial 911, you get law enforcement. So their role is investigation, tracking down criminals, making arrests, and as the screen shows, dealing with the booking or intake procedure. So if you've been arrested, you're brought to a police station, information is gathered, and then the police will make a report about that crime, the evidence collected, and that report will go to either a district attorney's office at the state level or the United States Attorney's Office at the federal level. And that is where we get to the court system. The district attorney or U.S. Attorney's Office, which are the respective prosecutors for the federal and the state system, begin what happens in the court system. The prosecuting office develops an information or a charging document. It's something that lays out the crime that this person or these people are alleged to have committed. It explains why that's a crime. It'll often cite to the particular laws that make it a crime. They'll include the factual information available, and they will submit that to the court. And that triggers the judicial system to get in motion for a particular defendant or defendants. And as this slide notes, it begins with what we call an arraignment. That's where a person goes in front of a judge. The charging document is read to them, or in some cases they say, no, I've read it and I don't need to hear it. But they're made aware of the crime or crimes that they're charged with. And then they're given an opportunity to enter a plea. They can plead guilty or not guilty. Then, once they enter the plea, the rest of the case begins to go forward. Now, there are some other parts of this process that happen, but they aren't really relevant for this topic, so I'm not going to bog you down in that. But suffice it to say, if the trial is going to move forward, you're going to have certain motions that are filed in the court. You're going to have the ability for the defense to gather information from the prosecutor, and then ultimately that's going to lead up to a trial. And that trial, more often than not, involves a jury of 12 people selected from the public in the area where the crime was committed. Those 12 people then will determine the guilt or the innocence of that particular defendant, or if you have multiple defendants, the same thing. You'll have a trial. Evidence will be presented. And evidence is an important term on this topic because there are two types of evidence. There's testimony. That's where someone talks under oath and tells what they know. Sometimes it's telling about what they saw. Sometimes there are people like forensic scientists, for example, who testify about the analysis they've done on evidence involved in the crime. Now, I used evidence there. The other type of evidence that you can have are things, documents, items that might have been used in a crime, clothing, physical objects that assist in understanding whether or not a crime was committed in this particular circumstance. So you have spoken evidence, testimony, and physical evidence that are tangible things that can be used to understand whether or not a crime was committed. After that presentation of evidence by both the prosecutor and the defense side, if they choose, the jury reaches a verdict. If it's innocent, the person walks out and the criminal justice system for that person is done. They no longer are part of it. If, however, they are found guilty, they enter what this slide calls the punishment phase. That's a really important part of this discussion because that is where sentencing happens, which is one of the areas of reform. Sentencing is still done by the courts, so we're still within the court system. Now, this is where I want to mention a really important word for y'all to understand: jurisdiction. Jurisdiction is a fancy way of saying what is the universe of things the court gets to do and decide. The court has jurisdiction to conduct the trial over the crime, and that court also has jurisdiction to impose a sentence for a person convicted of a crime. Now, we're going to talk a lot about how sentencing works in the sentencing video, but what's key to understand is that we're still within the court system, because you'll notice the next segment of the slide says that if you are punished, you are sent to the corrections part of the criminal justice system. That is where you go to prison. Or if you get probation, for example, you're set free, but you're supervised by parole officers, you're in the correction system. This is really important because affirmatives, you may see these affirmatives that attempt to reform how prisons work, how parole works, how anything to do with the correction system works, isn't part of this resolution. We are limited to the police portion of the criminal justice system, and we are limited to the court part of the criminal justice system, namely how evidence comes in through forensic scientists and how punishment is done, how sentencing works. So that's an important distinction to keep in mind. So that is the important part of the criminal justice system. Obviously, there's lots more, and you should learn about it, but those are the key basics you need to keep in mind. Now, let's talk about the federal system versus the state system, something I alluded to a moment ago. The federal government and the state government each have their own criminal justice systems. And they're all set up, like I said, pretty much the same. There's law enforcement, there's courts, there's punishment or sentencing, and then there's corrections. One segment of that system is administered by the federal government, and then another segment is administered by each state. So Wyoming has one, Colorado has one, Montana has one, so on throughout all 50 states. What differentiates the federal and the state system is what crimes they deal with. As you can see here, federal criminal laws deal with mail fraud, crimes that occur between multiple states, prescription drugs, bank robberies, because the bank system is largely regulated by the federal government. So you can think about it this way. If a crime spans multiple states, or a crime affects something that the federal government is the primary source of regulation on, chances are the federal system will get engaged. That means the United States Attorney's Office, wherever that crime gets committed, they will be the prosecutor. On the other hand, the state systems deal with probably what we would consider more regular or easily understood crimes. Murder, DUI, possessing drugs. So maybe the more straightforward basic crimes that we think about when we think about crimes. So the state system, again, you're going to engage the prosecuting office, which is a district attorney's office. You will have a defense. You will go through a court system. You'll have a jury trial, and you'll have a punishment and a correction system. So we're having the same process play out, but just under different jurisdiction. Again, that's why I mentioned the word is important. The federal government has jurisdiction over the crimes on the left, which means you can't have a state court deal with those cases. Likewise, federal authorities don't have jurisdiction over, for example, driving under the influence cases. The U.S. Attorney's Office cannot get involved in those cases. Now, there are a couple of exceptions where the state and the federal government have overlapping jurisdiction, so either one or both could charge a crime. But it is important as you think through this topic, argue through this topic, to understand the federal system versus the state system. And I'm going to tell you why in just a second, but before we get there, I want you to understand the difference in scope between the federal government criminal justice system and the state government criminal justice system. This is a breakdown of the number of cases overall compared to the number of criminal cases dealt with at the federal level. So I know the text is a little bit small, but there is approximately 31 million cases in federal and state courts that get filed annually. So every year there's about 31 million new cases. The federal government, the jurisdiction of the federal government extends to 1 million approximately of those cases. So the vast majority of cases, and this is true of both criminal cases and what we refer to as civil cases. That's where people are suing each other, or you're trying to figure out a will or a estate, things like that. The vast majority of cases occur in state court. And even of that 1 million cases that gets filed in federal court, about 10% of those, and this is the pie chart on the bottom, about 10% of those are criminal cases. So roughly of the 31 million cases that get filed annually, 100,000 of them, approximately, are federal criminal cases. So what that means for this topic is that the vast majority of the criminal justice system plays out in state courts, courts where jurisdiction is exclusive to the state government. That's going to be important for these reasons. First, the federal government has very limited and small jurisdiction. Sentencing guidelines, for example, and we're going to talk about that affirmative when we get to the sentencing video, but that is an exclusively federal item, so that provides good ground for the affirmative. But because the federal government has limited jurisdiction and the topic requires the federal government to do something, that limits the universe that the affirmative can really do, because what the topic is saying is the federal government should do something to change what goes on in the federal criminal justice system. But that's a small system compared to the state system. And as a result, you are, as the affirmative, unlikely to affect a large number of criminal cases if you limit yourself exclusively to the federal criminal justice system, which puts the affirmative in a bit of a problem, doesn't it? Because we want the affirmative to identify a large-scale harm or a large-scale problem and then deal with it. So what a lot of affirmatives are going to have to do to really compete on this topic is they're going to have to do something to try to affect the states. And that could be by incentivizing the states to follow through, coercing the states to do something, or actually attempting to take direct action to change state criminal justice systems. As the third bullet indicates, that raises the potential for federalism issues. And if you're wondering what federalism issues are, check out our video on the federalism disadvantage. But essentially, it means that an affirmative that tries to disrupt what's going on in the state's criminal justice system undermines the balance of power between the federal and state governments, giving rise to potential negative arguments for why that action would be bad. Finally, one note if you're negative is there's a potential for a solvency double bind. And again, it's based around this concept of limited federal jurisdiction and limited criminal cases that occur in the federal system. If the affirmative only affects the federal system, the wide-ranging impact of the affirmative is very likely pretty small. It's going to affect a small number of cases and a small number of crimes when compared to the whole. If, on the other hand, the affirmative wants to try to affect a larger number of cases and a larger part of the criminal justice system, then they probably have to do something to invade what would be considered the province of state courts, state jurisdiction, which raises our federalism issues. So it presents a double bind. You can either make a large ripple and large effect on the criminal justice system, therefore raising federalism issues, but in effect perhaps solving larger problems, or to avoid the federalism issues, you focus exclusively on the federal system, but by doing so, you limit the overall scope of your solvency. So keep that in mind when you're developing arguments. That leads me to basic ground issues that y'all should be thinking about. Reform, and criminal justice reform specifically, really posits a couple of things on this topic. You can either be more lenient or you can be more harsh. The affirmative is cast in the role of being more lenient. Lighter sentences, for example. Less authority for the police or a more lenient view of policing. Likewise, you can have more or less power. The affirmative will obviously want less power for the police. Maybe less power for how forensic science is used in the courtroom. Or maybe even it's more power for that. But those two, the tug and push of these concepts is really at the heart of what's going on. An affirmative that seeks more lenient sentencing invites arguments that we should have harsher sentencing. Affirmatives that seek less power for the police lead to arguments that maybe the police should have more power than they already have. So that push and pull will be, again, at the heart of reform. The states versus the federal government systems will be at the heart of this topic. You are going to have debates that center around this issue a lot. So getting to know the state's counterplan and the federalism disadvantage on the negative will be important. When you're affirmative, understanding how you could potentially reform what's going on at the state level is also important, or maybe being able to articulate why it doesn't matter that you would reform just the federal system. And then finally, again, one of the basic divisions of what is going to be argued about on this topic is, should we be tougher on crime, or should we be more reform-minded? Should we want to change the criminal justice system in the viewpoint that maybe it's about rehabilitation? We're not just out to punish, deter, take people off the streets. But you invite the flip side of that debate as well. And again, the reason I bring these up is you need to understand these concepts, but you also need to understand how these concepts translate into some of the specific arguments that we are going to argue this year. And if you're curious about those, check out our videos on that. So let me leave you with this. This topic may seem particularly complicated. It may seem big, but I think in reality it's going to be pretty small and pretty focused. The best piece of advice I can give anyone who is listening to this video and competing for this team: understand the criminal justice system. Understand how it works, because that will inform every affirmative and every negative argument that you will hear.